Whenever an infraction of public policy occurs, it is charged against a straw man, and since most individuals are not aware of their straw man, they believe it is charged against them as an individual. They try to use public law, argument of facts, to deny these charges. When you accept these charges, there is no controversy, and you then become the holder in due course, and these charges become your private property, which cannot be regulated in the commercial zone. When you accept your birth certificate for value, you're then the holder of the industrial bond, which it created. It's now held for both your benefit and the public's, but the public liability is no longer attached to the bond, or your straw man, which is now yours also. John Adams said, "I'm firmly of the opinion that there never was a paper pound, a paper dollar, or a paper promise of any kind that ever yet obtained a general currency, as money, but by force and fraud, that the army has been grossly cheated, that the creditors have been infamously defrauded. Some closed their shops to prevent being paid off with worthless paper money, that the widows and fatherless have been oppressively wronged and beggared, that the gray hairs of the aged and the innocent, for want of their just dues, have gone down with sorrow to their graves, in consequence of our disgraceful, depreciated paper currency." It appears that there has been a declaration of war upon the people of the United States of America. Whenever those in a position of great power, and without the consent of the public, use such knowledge and methodology for economic conquest, it must be understood that a state of domestic warfare exists between them and the public. Consequently, in the interest of future world order, peace, and tranquility, it was decided to privately wage a quiet war against the American public with an ultimate objective of permanently shifting the natural and social energy, wealth, of the undisciplined and irresponsible many into the hands of the self-disciplined, responsible, and worthy few. On March 9, 1933, Senate Document Number 43 of the 73rd Congress, First Session stated the following: "The ownership of a property is in the state. Individual so-called ownership is only by virtue of government law amounting to mere user, and use must be in accordance with law and subordinate to the necessities of the state." This was repeated in a hearing before the Subcommittee on Foreign Relations on February 17, 1950, in page 494 from the Constitution for the United Nations Industrial Development Organization, Treaty Document 9719, and the Communist Manifesto. In 1920, John Maynard Keynes said, "By a continuing process of inflation, governments can confiscate secretly and unobserved an important part of the wealth of its citizens. There is no subtler, no surer means of overturning the existing basis of society than to debauch the currency. The process engages all the hidden forces of economic law on the side of destruction, and does it in such a manner which not one man in a million is able to diagnose." House Joint Resolution 192, June 5, 1933, stated the following: "Resolved by the Senate and the House of Representatives of the United States of America in Congress assembled, that every provision contained in or made with respect to any obligation which purports to give the obligé a right to require payment in gold, or a particular kind of coin or currency, or in an amount in money of the United States measured thereby, is declared to be against public policy, and no such provision shall be contained in or made with respect to any obligation hereafter incurred. Every obligation heretofore or hereafter incurred, whether or not any such provisions is contained therein or made with respect thereto, shall be discharged upon payment, dollar for dollar, in any such coin or currency which at the time of payment is legal tender for public and private debts." Uniform Commercial Code 3, 419, Instruments signed for accommodation. If an instrument is issued for value given for the benefit of a party to the instrument, accommodated party, and another party to the instrument, accommodation party, signs the instrument for the purpose of incurring liability on the instrument without being a direct beneficiary of the value given for the instrument. The instrument is signed by the accommodation party for accommodation. An accommodation party may sign the instrument as maker, drawer, acceptor, or endorser, and, subject to subsection D, is obligated to pay the instrument in the capacity in which the accommodation party signs. The obligation of an accommodation party may be enforced notwithstanding any statute of frauds, and whether or not the accommodation party receives consideration for the accommodation. A person signing an instrument is presumed to be an accommodation party, and there is notice that the instrument is signed for accommodation if the signature is an anomalous endorsement, or is accompanied by words indicating that the signer is acting as surety or guarantor with respect to the obligation of another party to the instrument. Except as provided in UCC 3605, the obligation of an accommodation party to pay the instrument is not affected by the fact that the person enforcing the obligation had notice when the instrument was taken by that person that the accommodation party signed the instrument for accommodation. If the signature of a party to an instrument is accompanied by words indicating unambiguously that the party is guaranteeing collection rather than payment of the obligation of another party to the instrument, the signer is obliged to pay the amount due on the instrument to a person entitled to enforce the instrument only if execution of the judgment against the other party has been returned unsatisfied, the other party is insolvent or in an insolvency proceeding, the other party cannot be served with process, or it is otherwise apparent that payment cannot be obtained from the other party. An accommodation party who pays the instrument is entitled to reimbursement from the accommodated party, and is entitled to enforce the instrument against the accommodated party. An accommodated party who pays the instrument has no right of recourse against and is not entitled to contribution from an accommodation party. Based on these laws and quotes, it is a crime to pay an alleged debt. Code of Federal Regulations definitions. Definition of commercial crimes. Any of the following types of crimes, federal or state offenses against the revenue laws: burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame and like offenses, extortion, swindling and confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were a commercial crime. As you can see, all crime is deemed commercial by the so-called government because they want the money. Maxim in law. The money of the sovereign is his credit. He is the wealth for which no substance on earth can establish a value. Here is a quote from a 1933 Senate document. The ultimate ownership of all property is in the state. Individual so-called ownership is only by virtue of government law, amounting to mere user. And use must be in accordance with law and subordinate to the necessities of the state. (1832) President Andrew Jackson vetoed renewal of the charter for the Second Bank of the United States. 2 subsequent assassination attempts on his life proved unsuccessful. In 1871, the federal government formed itself into a D.C. corporation and adopted itself under the U.S. Constitution. 1873, 1884, 1893, financial panic, financial panic, financial panic. In 1907, a financial panic was provoked by J.P. Morgan to bring about total change and private control of the central banks and the monetary system. In 1910, the basic plan for the Federal Reserve Act was drafted at a secret meeting held at the private resort of J. 1938. Federal United States joined the International Criminal Police Commission, or Interpol, designating the U.S. Attorney General as the official representative to the organization. The Secretary of the Treasury was designated by the U.S. Attorney General as the representative to Interpol in 1958. Representatives to Interpol must, pursuant to Article 30 of the Constitution and General Regulation of Interpol, renounce their allegiance to their respective countries and expatriate. The World Bank is the agent for the creditors' principles of the federal United States and is not subject to American law. (1995) Oklahoma City, Alfred P. Murrah, federal building bombing. On the morning of April 19th, it is notoriously alleged that Timothy McVeigh, an ex-Army explosive expert, parked a rented Ryder truck with explosives in front of the complex and, at 9:02 a.m., a massive explosion occurred which sheared the entire north side of the building, killing 168 people. However, based upon additional evidence, the concrete columns just inside the building were set with small, high explosives, as it has been proven that a truckload of fertilizer could not have caused that amount of damage. 1 year later, a business across the street had discovered a tape recording of a business meeting that morning in 1995. On the tape was heard, boom, 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 and then a humongous boom. Per all the other evidence seen, established, researched, McVeigh most likely was a patsy or paid to do the deed, but you decide.